customary marriages, and of course brought and thrust back into the spotlight around what's going on in the monarchy in KZN. But we are now going to pick up where we left off yesterday with Zama Mopai, who is of course a lecturer in customary law at the University of Venda. And I'm rushing through this because I have questions that you want to ask Zama about this very complicated subject. It is so complex, and Zama, thanks so much for simplifying it. Welcome back.
Thank you for having me back.
Zama, we stopped yesterday where we were talking about dual marriages, where we get married twice. So, and that seems to be the norm around cultural aspects, and also not just that, if you look at Muslim marriages as well, and some other Orthodox Christian marriages where people tend to get married twice. So let's talk about that and the law.
Well, that's just us, isn't it? We just love to do things to make sure that things are done properly in all aspects of our lives. But then when it comes to the legal implications to that, for now, it's only with customary marriages because they are recognized. And the reason, if one could ask, why do we do that? For the indigenous community, the Black community, it's because of the past that we come from, where our customary marriages were not recognized as legally binding marriages. So to have a recognized marital status, people would then have to enter into civil marriages. But that did not stop us from still going into marriage by observing what our culture prescribes. So that is where the dualism comes in. The complication that comes with that, yesterday we even discussed the evolution of marriages in the Black community, that there was a time in the past, and that past, I said the timeline is very important. We're looking at before 1988, where Black people would enter even into civil marriages, but such marriages would have certain legal consequences different from other races in similar marriages. In this case, those marriages would be out of community of property. And also in that same timeline, a couple that is, or a spouse who is in a civil marriage could not enter into a customary marriage with, a subsequent customary marriage with another spouse or spouses. The other side of that being that a spouse who was in a customary marriage could enter into a civil marriage with another, and automatically the customary marriage would be nullified. We used to call, especially for the woman, would call them, they were called rather, the discarded wives. So that actually disorientated and actually really affected the family structure of Africans, because at the same time, you want the benefit of a recognized marriage, and it can only be granted to you if you register your marriage a certain way. At the same time, at the family level, things are in a particular way. So you find that in the past, because that is where actually it's most relevant. The past, our grandmothers, our parents come from a past of the dualism of marriage having so much of such complications. Actually, just before this interview, I was thinking of the old SABC drama, Wakwala Nyunini. You remember that, Sakina?
I do.
The story of Umfazwe
Yes.
and his many wives. That was a very classic situation for most families. So this dualism, when in terms of the law, this dualism is either by the couple itself, that me and my husband as a couple, we are in dual marriage. We have a customary marriage, we have a civil marriage, but one of those marriages, depending on which one is recognized, would actually, which one is registered will be recognized. But then in polygamous household, it's a different story, because this dualism, it's not just with the couple, it's with the husband And amongst his wives, there are different kinds of marriages. Now, the question is, what is the implication then where you are in a polygamous household? One wife is of this particular marital system, another is of another marital system. That is where the challenge is. But even then, the challenge observes a particular timeline because the law has been changing. Actually, it's very, very difficult to keep up with the changes regarding marriages where black couples are concerned, because there's just been a lot of amendments just to try to solve this problem. And these amendments, when they come, they already find that things are already complicated on the ground.
Zama, if one goes through a customary marriage, is that automatically in community of property? And let me just put a question from one of our viewers alongside that. It says, I really want to find out about prenups in a customary marriage. My understanding is that after lobola negotiations, you are automatically married in community of property. So do you sign a prenup before the lobola negotiations? I'm asking because a friend of mine died after lobola negotiations and celebrations, and he had intended to do a prenup, but it didn't happen. So how does it work?
You see that one, Sakina, it's one of those very tricky ones. But then the legal answer is this: yes, the current customary marriages, and I can't stress enough that when you deal with customary marriages, when you deal with marriages by Black South Africans, timeline, when was the marriage entered, whether it was civil or customary, really plays a significant role, because the consequences are just not the same. But if you are asking me of a marriage now, today in South Africa, a customary marriage, yes, it is by default in community of property. Now, of course, every in community of property can be excluded by anti-nuptial contract. The question now was when. Ideally, it should be before you even start the process of the negotiations of the entrance. That is the simplest way. But then the Recognition Act also has a gap wherein, because you can convert a customary marriage to a civil marriage. People don't know that they're actually converting. They just simply know that we went through lobola negotiations and we did that, and now we are going to sign, they say. And then when they sign, then now they are signing into a civil marriage. From our side, they simply just converting. And during that period between the customary marriage and the signing into a civil marriage, most will do their anti-nuptial contract there. Now, in terms of the law, that is a bit faulty. But if it is the couple, just the same, the couple, it's not with another party, it doesn't seem to present much of a problem. But the proper procedure is to have your anti-nuptial contract drawn and signed before the negotiations. My students would ask and say, but ma'am, can you imagine me presenting an anti-nuptial contract to the uncles at the lobola negotiations? And they would ask me, you have already went ahead to get married to this woman or to this man. It wouldn't sound great, but then that is the proper procedure. People can just take advantage of the gap where they are now converting their customary marriage to a civil marriage. Then they can actually enter into an anti-nuptial contract for the civil marriage. But even then, it is not as simple as I'm saying, because it can be challenged. So the proper way is to have it before.
So, Zama, we are pressed for time, but just a quick one, and I think this is important. Given that there is now recognition of customary marriages, how does one then dissolve a customary marriage? Because is it as simple as taking whatever lobola was paid and returning it, or a dowry? How does it work? And is it necessary for you to actually nullify that customary marriage to be divorced, as it were, legally divorced?
Oh, well, this is not one of those favorite topics for me concerning customary marriages, because it's just disorganizing a whole lot of things. But the law as it stands is that the only way out of a customary marriage is by obtaining a decree of divorce from court. You cannot just treat it as an engagement like most people still do. You cannot just dissolve it at a family private meeting. You need to have a decree of divorce. In fact, to simply put, the same way we dissolve a civil marriage is now applicable to customary marriages. Then every other thing that you do according to your culture is actually things that you are allowed to do, but does not have jurisdiction to dissolve that marriage. So simply put, extrajudicial dissolution of customary marriages is not recognized in South Africa, and that can be a bit problematic because people are just not doing it, and it has its own legal consequences, even affecting other people.
Zama Mopai, thanks so much for your time. Customary law expert and lecturer at the University of Venda. Zama Mopai speaking to us about customary marriages and unpacking the law as it stands around some of these issues. See, I didn't know that, Leanne, and I don't know how many people did, that you can't just walk away from a customary marriage.
Yeah.
You actually have to go through the process to go and get a legal decree from a court of law to dissolve a customary marriage.
Yeah, this is a vital conversation. I think a lot of people are being very much so educated as this goes, with not actually knowing their rights and not knowing how these things work in conjunction with, the law of South Africa, customary laws, and how it all binds together. Very, very difficult.
As Zama says, it's complex, but you know, it's necessary that we understand. You can't just go to your uncles and have a quick family gathering on both sides and say we are divorced. It doesn't work that way.
Wow. All right, well, I hope you enjoyed that, and that's where we got to leave it.